So we'd like to acknowledge that we are presenting today this session on Treaty 1 territory, where the Occupational Health Center is located, the traditional territory of the Anishinaabe, Cree, Oji-Cree, Dakota, and Dene peoples, and the homeland of the Métis Nation.
Hi, Tiffany, it's Chris calling you back.
Occupational Health Center acknowledges that we are all treaty people and recognizes the history and impacts of colonization on Indigenous peoples. We commit ourselves to active accountability, justice, equity, and reconciliation. So having said that, I'm just going to stop sharing here and hand it over to Sandra. So welcome, Sandra.
Yes. Hi. Good morning, everybody. Thank you for joining us today. I'm going to be speaking today about the place that I work, Community Unemployed Help Center, our services, and how we help people every day. Here, I'm going to share my screen and let me see here. Here. Can you see it? Can you see it now?
No, I don't see it, Sandra.
No.
Yeah, now we see it.
Good. So I work at the Community Unemployed Help Center. My name is Sandra Guevara-Holguin, and I'm an employment insurance and an employment and income assistance advocate. And I've been doing that, as Lisa mentioned, for 14 years, going on 15 now. So who we are. Community Unemployed Help Center was established in 1980 through the efforts of labor and community representatives. We're a nonprofit organization funded by United Way of Winnipeg, the Law Foundation, local unions, the province of Manitoba, and the private donations. And we are completely independent from both federal and provincial government. And where you can find us. We're excited to announce that on February 21st of 2023, we moved to our new offices at the Union Center building's main floor. So now you can find us at 102B, 275 Broadway. So needs identified, how we came to be. Back in 1980, labor and community representatives identified the unmet need for advocacy for unemployed workers. Workers are denied employment insurance benefits frequently and need assistance to start the appeal process. Only a few lawyers take employment insurance cases. In fact, we have many lawyers calling us to ask for our advice on the Employment Insurance Act because they don't know how it works. Because they don't specialize on that. Workers, and the good thing is that workers do not need a lawyer to go to the administrative tribunals, like for example, the Social Security Tribunal. You don't need a lawyer to go there. In the case of EIA, Employment and Income Assistance, in 2011, the Manitoba Ombudsman published a report in which included a set of recommendations in order to improve the Employment and Income Assistance program. One of them was to provide greater advocacy services to vulnerable people that required to appeal or ask for reconsiderations of EIA decisions. As a result, the Manitoba government signed a funding agreement with CUHC to implement the EIA advocacy service. So to date, still, there's not enough advocacy services in the community. So that's why what CUHC has been doing over the years is also providing webinars regarding EIA advocacy to other agencies in the community, just to kind of train other service providers into how to tackle EIA issues or how to help people with EIA concerns. What we offer to the community? We offer advocacy, representation for people having problems, concerns, questions regarding both systems, employment insurance and employment and income assistance. Information and advice to the public in both systems, such as this presentation, one-on-one or collectively. Referrals to fellow nonprofit agencies and government offices in the community if we cannot help them directly. We promote social policy analysis and we promote public interest advocacy. What we do on a regular basis is we meet with both employment and income assistance management and employment insurance management in order to let them know what we see on the field, what is not working, what should change, what can be improved. As a result of those conversations over the years, CUHC has made possible significant changes in legislation. For example, in the case of employment insurance, as a result of our ED Neil Cohen's work many years ago, the compassionate care benefits criteria, eligibility criteria changed because Neil took a case all the way to the Federal Court of Appeal, and the criteria of who gets compassionate care benefits changed. And now anybody that is considered close to the person that is ill can get compassionate care benefits. Before, it was only for parents or siblings, nobody else. So now it has changed to anybody that is considered close. And that was as a result of Neil taking it.
Just for Prem, it's Angela calling from Occupational Health at Victoria Hospital. I'm just following.
Oh, hello? Yes, okay. Okay, so that's one change, for example, in the EI piece. And on the EIA portion, when the SERP started started being given to people, unfortunately, many people applied by mistake, thinking that they qualified when they didn't. And those people were enrolled at the same time in EIA, in social assistance. So the social assistance program started penalizing these people for doing that. So that these people ended with two debts, one on the EIA, one to the EIA system because they were collecting that at the same time, and one with CRA because they were collecting SERP incorrectly. We advocated with the province to find a solution to this problem. We explained to them that, yes, these people do not qualify and did not qualify for SERP, that they applied, by mistake. And they do have a legit debt with SERP and with CRA. And therefore, they will have to pay that money back. However, they never stop qualifying for EIA. After many conversations and many negotiations, we arrived to an agreement with EIA that EIA will not penalize these participants as long as they establish a repayment plan with CRA. And that has been going on for now a year and a half. That as long as there's proof that they have reached out to CRA to set up a repayment plan with them, EIA will not penalize them and they will be allowed to re-enter EIA and get their full benefits. And all our services are provided free of charge. What is CUHC's structure? We are small, but we do great things. We have 5 full-time positions and 1 on-call position. Our ED executive director is Neil Cohen. We have an intake and office coordinator, Amy McGowan. And we have 3 full-time advocates, Erin Lyle, Ashley Harvey, and me, Sandra. And also we have an on-call advocate, Doug Simpson, that will come as needed when any of us is going to be leaving for a long period of time. So what's the process? When somebody calls, what's the intake process at CUHC? Our intake coordinator receives a call to our main line or through the Community Financial Helpline, that it's a line that we share with Seed Winnipeg, with ERCOM, and with Community Financial Counseling Services. And they will transfer the call to us. Amy will return the call within 24 hours whenever possible, because we are small. Therefore, in certain times of the year, we could be short-staffed. And so this time will be a little bit longer, but we always thrive to call people within 24 hours in order to assess if this is an information call, meaning that it's just a question that can be answered directly by Amy, or if the person needs the intervention of an advocate. Amy will be the one who handles the info calls, if she's able to. For example, how many hours do I need to qualify for sickness benefits? Kind of deal. She can answer those things very fast. If the client is assigned to an advocate, so then the process is as follows. Now, one thing also, we have the policy that, if you are assigned to an advocate, that's the advocate that you get, right? Because sometimes people, when they don't agree with what you're telling them regarding their case, they would like to get another advocate. Unfortunately, we cannot do that because we're too short-staffed. So the advocacy process. The advocate assigned to the case will contact the client directly to determine what is the need. And these are the most common scenarios. The client has received a decision letter and wants to appeal it. Either, and we're talking about both systems here. Usually there is, not usually, there's always, and there has to be, a decision letter saying, you are denied. Hopefully they explain why, okay? On the EI portion, they usually tell you why. On the EIA, sometimes it's like a little bit vague. The client already, that's the first scenario. The second scenario is that the client already appealed it or has already initiated the process and has an upcoming hearing. So then we have to assess when the hearing is, right? Because if the hearing is tomorrow, then we most likely will have to request an adjournment to that hearing because we won't have enough time to prepare. The client needs to know how to request certain benefits, right? And that's maybe it will be, and the need for an advocate, it's because they need to assess eligibility, because they need to tell you what the circumstances are. And based on the circumstances, the advocate will be able to let them know whether or not they qualify and for which benefits. So the questions that we ask to sometimes ourselves, sometimes to the client is, when was the client denied the benefits requested? Because deadlines are important. They are not set in stone, but they are important, okay? It's not the same to be maybe a week late than to be 6 months late, okay? Or 8 months late. It makes a huge difference. Why was the client denied the benefits that they applied for? Has the client sent any new and or additional information in order to ask for a reconsideration? Because maybe we don't need to appeal, we just need to ask for a reconsideration by sending new information. Is there a second decision on the case? So maybe the reconsideration has been exhausted and there's no other avenue but to go to a tribunal at this point. Is there a legal argument that can be made in order to challenge a decision? And that is key in order to determine whether or not we're gonna represent the client. Our policy is that if we cannot make a legal argument, meaning that if we cannot use the law or the regulations on behalf of the client, unfortunately, we cannot represent the client. And the legal argument can be weak, but as long as we can make an argument, we will represent the client. Can this be resolved informally in a conversation with a government agency? So we have to make that decision right away, thinking, okay, do we need to go to an appeal? Or maybe this can be solved quickly through a conversation with an agent. The initial paperwork that we provide to the clients to become our clients are the intake form that we have for both EI and EIA, and we will ask certain questions like which area of the city you live in, if you have dependents, if you are you consider yourself female, male or other. Those are that kind of information is collected in order to provide our stats for our funders. We have the authorization to disclose information in each of the systems. That is key. Without that, we cannot even call the agents. And we have the client service agreement. That is an agreement between us as advocates and them as clients as to what is expected from them and what they should expect from us. And so what do we do next? We establish a good communication strategy with the government agent in charge of the client's case. Okay, we establish what is the best course of action here. We determine if there is any new information that is needed in order to revert the initial decision. For example, in a case of a denial of disability status under EIA, maybe it's a matter of getting a letter from the doctor, just specifying a little bit further the client's medical condition. And with that, we will make a huge difference instead of going through the whole appeal process. If that is the case, assist the client with getting such information. So reaching out to the doctor yourself and asking them specifically with information that we need. But again, if that doesn't work, then inevitably we will have to go to an appeal. What should the client expect from us as advocates? To prepare and promptly submit all documents and information to the appropriate agency on their behalf, keep them informed of developments regarding their case, maintain complete confidentiality of your personal information in accordance with the Privacy Act, provide you with a clear explanation of your case, the pros and the cons and the chances of success, inform you if there is no case in law and explain why we are unable to represent you. And that is a really hard conversation in most of the cases. But if we are not able to represent you, we will always, if you wish to proceed on your own, we will always explain to you what you need to do. We will coach you for sure, but we cannot go with you. And what do we expect from clients? Attend any scheduled meetings with the advocate at the scheduled time. If not, if you can't, just let us know in advance. Inform the advocate if you are unable to attend. Provide the necessary documents and information as required, because the problem is that, and it's very common, unfortunately, that the client explains to us what's going on, but then when we reach out to the agent, we find out things that we weren't told in advance. So there has to be a trust relationship between client and advocate, and that is key. Because we always say to clients, if I cannot trust you, I cannot represent you. And if I cannot believe you, an admin tribunal or an agent won't. So credibility is key, and trust too. Keep the advocate informed of any developments regarding your case. And that's very common, mostly on the EI system, that the agents will call the client directly and they won't call us, even though we are listed as representatives. So they have to let us know if EI called them first. Report any changes in contact information immediately. Accept financial responsibility for any and all medical documents because we can afford paying for those. If the client cannot afford it, we are always willing to ask doctors to waive that fee for them. Understand that a successful outcome cannot be guaranteed. and attend the appeal hearings. That's key. We don't represent people if they are not there, even at least on the phone. If you cannot be there in person, you can be there on the phone. We do not represent people if they're not there. Okay, that is our policy. And also in the case of the Social Services Appeal Board, that is the admin tribunal for EIA, they won't proceed if the person is not there. The EIA reconsideration and appeal process. This is how the appeal process works with social assistance. As an example, if you applied for disability status and you were denied, for example, that's an example, right? Or you were denied anything under the social assistance program, the first step is to request a reconsideration, okay? That's faster than, like you can get a decision like that with directly with the case counselor. If you provide additional information, okay? Always ask your case counselor why you were denied. That's key. People can always ask why. People shouldn't be scared or intimidated to ask why you're being denied. If you feel that you're not being heard, please contact either the financial helpline or CUHC to start the process for you. Once we review what has been provided so far, we will reach out to you and request the necessary information to send to EIA on your behalf. If despite of providing new information, you are denied again, then we will proceed to appeal to the Social Services Appeal Board. And how it works is that the Social Services Appeal Board will send the appeal request to the EIA department. They will provide a docket with all the information that they used to, for example, deny a person the disability status, or how it's called now, they have a fancy name for it now, medical barriers towards employment. That's the new name for the disability status. So they will provide all the information that they used to deny the person, and we will proceed to ask for a hearing date. Okay, so we will go in person to a hearing date with the client, and we will be there to explain why this client should be on the disability status category. That's how it works, the appeal process. So the EI reconsideration and appeal process. This is on the EI portion of it. The reconsideration process. This is a mandatory step to the appeal, meaning that on the EI, different from the EIA. In the EIA appeal process, the reconsideration is not necessarily mandatory. You could appeal directly to the board without going through reconsideration if you decide to, depending on the case. I could do that if I see that the person has already gone to reconsideration and they said no, or if I see the medical documents that they have already provided from the get-go, and it's evident and obvious that the person is disabled, for example, and they've said no. When the case is obvious, it's just evident, then I won't go to reconsideration and I will go to an appeal directly. An EIA, you can do that. On the EI system, you cannot. You have to go to the reconsideration first. It is mandatory, meaning that you have to ask for reconsideration to employment insurance. From the day that you are initially denied your EI benefits, you have 30 days to appeal, to file for a reconsideration, 30 days. This deadline can be extended. You can apply late if you have a good cause for it. Sometimes is that they mail you the letter because they just issued it without calling you, or they couldn't reach you or whatever, or they sent it to the wrong address, and you actually found out beyond the 30 days, right? Within a reasonable time. That can be accepted. and you will get to reconsider, okay? But if you receive the decision and months passed and you never file a reconsideration, then you cannot ask for a reconsideration. You will be denied, okay? Unless you provide like a really good cause for each day that you were late, for each day. And very, very severe circumstances. I don't know, you were critically hospitalized during the whole time, incapacitated, maybe incarcerated. Very extreme circumstances could allow you to reconsider, could allow a late reconsideration. Other than that, you have 30 days. Onus of proof. If you, for example, have been denied because you were fired for misconduct, meaning that you did something, supposedly they think that you did something on purpose to lose your job, or you quit without just cause, meaning that according to them, your cause for quitting is not contemplated in legislation, right? So the onus of proof varies, meaning that who has to prove that they should be eligible changes. In the case of misconduct, if you've been denied because EI has found that you did something knowing that by doing that you would get fired, right? Who has to prove that is EI and the employer. You don't have to prove anything. In the case of quits, it is your responsibility to prove it. Okay? So that's why quitting versus dismissal, it's easier to get EI with a dismissal than with a quit. But it is a myth that if you quit or get dismissed, you don't get EI. It is a myth. My advice to everybody is no matter why you stopped working, please apply for EI and let them decide. And if you get denied, you call us. And we will see the case and see what's going on and evaluate the circumstances. So CUHC can participate by sending the request for reconsideration if you have just been denied and you haven't initiated the process, or if you have already filed your request for reconsideration, we can reach out to the reconsideration agent on your behalf to have a teleconference between the three of us, because usually the reconsideration agents are based either in Saskatchewan or Alberta, and sometimes they call you even from we have gotten calls from Quebec occasionally, but usually they're in the West. So so then BC even. So then we can set up a teleconference between the three of us and discuss your case and win the case at the reconsideration level without having to go to the next. Okay. Now, let's say we are not successful at the reconsideration level. Then you have 30 days from the decision of the reconsideration to appeal to the Social Security Tribunal, or SST. Okay, that is the admin tribunal from the federal government for cases related to employment insurance. CUHC can send a notice of appeal to the Social Security Tribunal on your behalf, even before we decide to provide you with full representation. Why? Because sometimes people come and they tell us what happened, right? And again, we don't know all the facts. We don't know what the employer has provided. In order to know all of that, we have to have access to the docket. And that will come once we appeal to the Social Security Tribunal. So we have to explain to the claimant that yes, we will send a consent showing us as representatives to the Social Security Tribunal. Once they send us the docket, we'll see it, we'll read it, and that's when we will conclude, if we are meeting the client at this stage, of course, we're going to conclude whether or not we can make a legal argument, right? So again, that is if we meet the client when they have gone through the reconsideration on their own, and now they want our help for the Social Security Tribunal. Now, we have to advise our clients and warn them that now the Social Security Tribunal has appeal process has become very slow, very slower than never before. In average, the waiting time is 7 months until you get a hearing date. And that is really serious. Before, when it was just created, it was way faster. And then about 2 years ago, I would say before the pandemic, they became completely digital. And we will get hearings in a week, even too fast. They were so fast that I had to ask for adjournments because it was too fast for me. I didn't have enough time to prepare for hearings. And now I have to follow up constantly to see when I'm going to get a hearing. So yeah, it is slow. However, if I really believe that there is a case, I will take it. And why? Because decisions at this tribunal set precedent. Meaning that if we are successful in a particular case, it will be helpful for others. So that is why it's worth the wait if we are successful. And now some of the highlights of CUHC in the last year. We have provided information, advice, and representation on EI and EIA and the CERB benefits program, because we're still doing that. We became some kind of not the experts, but the information source for CERB during the pandemic to, and I cannot see I cannot see the number here because of to 1,369 individual clients during 2022. We returned over $475,000 to CUHC clients in benefits and benefit entitlement previously denied. We represented the Manitoba Federation of Labor on the Canadian Labor Congress Employment Insurance Committee that develops EI policy and campaigns for EI reform. And as a result of that, after years and years and years of advocating with other fellow agencies all over Canada, we got, in December of 2022, we finally got the extension of the EI sickness benefits from 15 weeks to 26. We have been asking for that for years. And finally, we got them in December. So now, as of December 15th of 2022, any EI claim for sickness benefits could be extended up to 26 weeks. And that is a huge, huge accomplishment. And it's a huge help for all the workers in Canada that don't have paid sick leave through work, and that unfortunately will need that time to recover. So it is great. And we are really happy about that. And we successfully appealed employment insurance decisions to the Social Security Tribunal regarding overpayments generated as a result of EI regular benefits provided to full-time students during the pandemic. And we have set precedent for future similar cases. So as you know, during the pandemic, the EI requirements changed dramatically in order to make more people eligible for EI. So really young people, students, became eligible for EI for the first time in their lives, and maybe the only time in their lives, because they only needed 120 hours of work in order to qualify for EI. That made many full-time students eligible for EI. So they applied. After a couple of years, EI started sending overpayment letters to these kids with overpayments as big as $15,000, saying that they did not qualify because they were full-time students. Therefore, they were not available for full-time work. We have advocated for at least 3 students that were under those circumstances, proving that because they were online students and their courses were, they didn't follow a fixed schedule, that they were on their own time, they could, because they were looking for work. And again, they were in the middle of a lockdown, so there was not a lot of work to look for, at the same time, but they were available for work if they would have found one. And the Social Security Tribunal agreed with us in the 3 cases. And that's why it set precedent. And those kids are now debt-free. And we're really happy about that. Sorry. Thank you.
Thank you, Sandra. That was really informative. I know working as an NP for years at clinic, these systems are complex. EI, just trying to understand them, EI disability, EIA, and this is really informative. So thank you for that. And so we're just a really small group. There's only a few people. So I think I have a few questions actually for Sandra, but I'm going to first just, if you do have a question, just actually ask Sandra instead of putting it in the chat. But if the folks that are here don't have questions, I have a few that I would like to ask. So maybe I'll just give folks a second. So maybe Sandra, so the couple of questions that I had for you. So in the beginning, you had said that workers are often denied EI benefits. And so my question is, if you can maybe just briefly what you've seen, what are the most common reasons people are denied, like not only for EI benefits, but for EIA and EI disability, like just generally, what are the most common reasons that you've noticed that people are denied?
Well, quit is a very common reason why, because the criteria is, the legal test is that in order to quit, you have to prove that you exhausted all reasonable alternatives, right? Before you leave your job, and that you had just cause for quitting. And there's up to 40 reasons in the EI regulations considered just cause, but if you have one of the 40 reasons to quit, it's not enough. It's a combination of having one of those plus proving that you exhausted all reasonable alternatives before you decided to leave. And by reasonable alternatives, EI considers looking for alternative work at the same time, even if you didn't get it, at least applying for other jobs, talking to your employer to find a solution to the problem that is bothering you and might cause you to quit. Then what is the other one? Well, basically those two, looking for work and talking and trying to fix it, right? Or maybe if it's possible, maybe ask for a leave of absence or a sick leave, right? And just not end the working relationship, but just put it on hold, take a break, and then come back and see if that helps, right?
Right.
So because how they think is that any job is better than no job at all. And if you're putting yourself in an unemployed position voluntarily, then it's because it was so unbearable that you could not stay.
Right.
So then that is one of the main reasons why people get denied.
For EI.
For EI, right? However, that doesn't mean that if you quit, you don't get EI automatically. There's many people that do get it because, for example, you quit for health reasons because the work is making you ill.
Right.
Right? It's directly affecting your health. And if you prove that with the support of your doctor, you should get EI. Right? Another reason why people get denied EI is because they are not available for work. So they get approved for EI because the reason for separation is approved. But then once they start collecting EI, they are deemed not available for work.
Right.
Because they are compromising their availability by, I don't know, going back to school in a non-sponsored training. And by sponsored, I mean through Manitoba skills and development set. Like again, they change names every year. So I think the latest one is Manitoba Skills and Training or something like that. That is the one on Lombard, 111 Lombard. So that's the only way that you can do it, through them, right? But if you go and you sign up yourself to, I don't know, for example, Red River College, you will get cut off because you're compromising your availability for work. If you're collecting regular EI, you have to be available for work tomorrow at 8 a.m. So you cannot compromise your availability. So that is another very common situation. If you have, for example, if you become, if your childcare arrangements fall and you have to be taking care of your kids full time, then you cannot collect regular benefits or any benefits at all because you are not available. So that is very, that's another reason, for example, for seasonal workers, right? For, that's very common in cases of educational assistants, for example, that get laid off in the summer. And they don't get paid through the year like teachers do. So they have to apply for EI. But they have a recall date in September. So every time you have a recall date, EI will look at your availability and see if you're looking for work during the summer, because they don't want you just waiting for your recall date. And that's always been complicated.
Yeah. It's very complicated.
Yeah.
Very complicated. So another question, I'm not sure if I'm going to articulate this well. So for example, this is regards to EIA insurance and compensation. So workers' compensation. So EI insurance and workers' compensation for workers who've had work accidents or occupational illnesses. So my question is, can sickness benefits, so if you're eligible for EI sick benefits, can they be paid to you while you wait for a reply from WCB?
Yeah, they could. They could. However, if you get a back pay, then you have to return your EI.
Okay, that's what I was wondering.
Because you cannot get both.
Right. So it's possible that EI sickness benefits may kick in quicker than your WCB claim.
And again, that's also, you know, we don't know, because right now we're seeing that the waiting time from the time that you apply to the time that you get your first check, even if it's sickness, that should be a no-brainer, because the only thing that they see for sickness is how many hours you have in the last year, that is 600 hours.
Right.
They don't care about why you stopped working. Right? Like for special benefits, the only criteria is how many hours you have in the last year.
Right.
So
worked, how many hours you've worked.
Yeah, that's it. So the adjudication should be fast. However, we're seeing that from the time that you apply to the time that you see your first check, it can be 4 weeks or 6.
Okay.
So whatever kicks in first. But the matter of the fact is that you cannot collect both at the same time.
Right. And so
and the workers' compensation is first. So then when that's over, if 2 years haven't passed, then you could collect your EI sickness benefits.
Okay. So should you, and I'm not sure this is the right question, but so should you as a worker, say you were injured, and you are, say, eligible for EI sick benefits and WCB, you're putting in your WCB claim, should you also apply for EI benefits at the same time? Yes. So what you're saying is that workers, if they are eligible, and how would a worker know that they are eligible for EI benefits? How would I know that?
For your number of hours.
For your number of hours, like 100, you said 120?
600.
600.
The last year.
in the last year. So what you're also suggesting, if I heard you correctly, is that if I'm injured at work, that I'm putting in my WCB claim, and at the same time, if I'm eligible for EI benefits, I also should be putting in.
Yeah, because in the application, they will ask you about workers' compensation.
Okay.
And have you applied, as of when, and whatever. So they will know.
Okay.
They will know.
Okay, gotcha. And then my last question, I'm going with all the questions here, is, so one, are you folks now at CUHC, are you folks just doing virtual appointments, or are you opening that up to in-person? And then
it can be in person, it can be virtual, it can be on the phone. Whatever accommodates the person, we're there.
Okay. And then
how drop in now.
And sorry, drop in?
Yes.
Okay. Okay. You're doing that now. Okay, great. And then how quickly, it sounds like, Sandra, it's pretty fast, like, especially if folks just have a few questions if they call Amy, often she can do a lot of troubleshooting on the phone. Yes. But how quickly can folks expect to get an appointment with you if they need your services?
You know what? It's pretty quickly, maybe 1 day, 2 days.
Okay, that's very quick.
And you can meet with us, like that's, and again, as I said, we try to return calls within 24 hours as much as possible.
Right.
Because sometimes they call, they leave a message, or the advocate that you're going to be assigned with is not available at the time that you call. Because sometimes you can straight go, like you call, and if, for example, the Amy's assigning the client to me and I happen to be available, she will transfer it right away.
Okay.
She will talk to me right away, right?
Yeah.
And then sometimes you don't even need to come. I can send you the forms online and you can return them to me, and I can start the process by doing that. You don't even need to come, right? Yeah. But some people prefer to meet with me in person to explain everything. And the good thing about us is that we have the time to sit down with you and discuss everything. Yeah. And that's the key difference between us and government agents. And it's not their fault. It's just because they are so overworked. They have such a huge client base that they cannot sit down with you for like 40 minutes or more to discuss everything that you are going through. Yeah. So that is the huge difference between them and us. So then, we're always welcome to do it.
Yeah. And I think too, so often you must run into also, I bet a lot of people just are so rushed in some of the different systems, and that they don't necessarily may hear the correct information. They may have a misunderstanding of what was said to them. And I'm making an assumption here, but I would think that a lot of the work that you do also is just making some clarifications or pointing somebody in a certain direction. And maybe that's all that's really needed, right? It's just that when you're in that other system and they don't have the time and they feel rushed and they're not understanding and they don't have somebody with them, a family member, you don't hear, you're stressed already. So I think, and I also just want to say that, small but mighty. I feel that's also the term we use for the OHC, small but mighty. And I think just what you mentioned, the accomplishment of the CUHC with that EI sickness benefits from 15 to 26 weeks, like huge accomplishment, right? Huge success. So I just want to say thank you so much, Sandra. I know it's a small little group today, but I think that really doesn't matter. I think it's important to get this message out, and I'm hoping that the folks who are here enjoyed it, and I certainly have. I've learned a lot, so thank you again. And I think Jeffrey put something in the chat. So yeah, I think we're probably good. So if folks don't have any questions, again, a big thank you to Sandra. No,
thank you for having me. And it's going to be recorded so anybody can access it and information. And we are, as I said, we're in the Union Center building, main floor. You can come in. We're open from 9 to noon and from 1 to 4:30 from Monday to Friday.
Okay. Great. Well, thank you again, Sandra, and have a wonderful day, everybody, and enjoy your summer. We're doing another speaker series probably in September, so stay tuned for that.
Okay.
Bye.
Bye.
Thanks, Sandra.
Thank you.
Bye.